All right, let's go ahead and get started. Again, welcome to our presentation on advocating for the release of immigrants as immigration detention ends in the state of Illinois. My name is Ruben Loyo. I'm the Associate Director of the Detention Project at the National Immigrant Justice Center, and I'll be co-presenting today with my colleagues Heidi Altman, who's our Director of Policy, and Dave Faherty, who's a supervising attorney on our detention project. Next slide, please. So for those of you who are not familiar with NIJC, we're a nonprofit legal services organization, and we advance immigrant rights through a combination of direct legal services, federal litigation, and national and local policy work. We have 5 offices across the United States, and annually serve over 9,000 immigrants, thanks in large part to the help of 2,000 pro bono volunteers. And it's our hope that after today's presentation, several of you who are joining will join us in our pro bono advocacy. Next slide, please. So let me just provide a brief overview of our presentation today. I'll start off by just providing an overview of why we're here, and that's the recent enactment of the Illinois Way Forward Act in the state. I'll talk a little bit about what it does and what it means for immigration detention in the state of Illinois. At bottom, so this type of legislation presents the federal government with an opportunity to really examine the need for immigration detention. And so we'll talk a little bit about some of the just closures advocacy work that's been occurring both locally and nationally. And I'll hand it over to my colleague Heidi Altman to talk a little bit about a recent experience that we had with the shutdown of one of the Illinois immigration detention centers in Pulaski County earlier this year. We'll then transition to talking more about how it is that you all could potentially be involved in some of our advocacy to help people who are detained in the Illinois immigration detention centers. We'll provide a brief overview of ICE Detention Authority and release advocacy before ICE. I will note that today's presentation primarily concerns advocacy that you can do before Immigration and Customs Enforcement. This is administrative advocacy. We won't cover the subject at length of representing individuals in bond proceedings before immigration judges, but we'll share some information and some resources about that in case you are interested in that. And then we'll transition to talking more in detail about the types of release requests that can be submitted on behalf of individuals who are in immigration custody. My colleague Dave will talk about how to draft them, what types of materials and evidence can go into release requests, and how you can escalate these requests to officials in headquarters, officials at much higher level, in the event that they are denied by line deportation officers. And then, of course, we'll leave some time for Q&A. If you have any questions during the course of the presentation, feel free to include them in the chat. We may get to them in real time. If we don't, we'll just cover them at the conclusion of our presentation. Next slide, please. So we'll start with an overview of why we're here, and that's again, this presentation, by the way, is happening on International Human Rights Day, and we're here to talk about a recent human rights victory at the local level, and that's the passage of the Illinois Way Forward Act. Next slide, please. So as some of you may know, Illinois has really been at the forefront of legislating protections for immigrant communities. 4 years ago, Illinois passed the Trust Act, which really limited cooperation between local law enforcement entities and the federal government with regard to federal immigration enforcement. So most notably, it limited and prohibited really local jurisdictions from honoring immigration detainers, which are requests from ICE to local jurisdictions to hold people for the purposes of transferring them to immigration custody. So this year, Governor Pritzker signed into law the Illinois Way Forward Act, which made some changes and added to the Illinois Trust Act, most notably by including a provision that called for the end of detention contracts in the state of Illinois between local government, local jurisdictions, and U.S. Immigration and Customs Enforcement. It also updated other legislation in Illinois that provides protections to immigrant communities, most notably the Voices Act, which is a piece of legislation that provided protections for immigrant survivors of crime so that they can avail themselves of U visa protections. So with the Illinois Way Forward Act, Illinois is now part of what is a growing movement of states across the country that are taking action to end ICE detention contracts within their states. So in addition to Illinois, there have been similar efforts in New Jersey, California, Washington, and most recently you all may have seen in Maryland, a legislative initiative passed and was vetoed by the governor, but there was an override of the veto recently. Next slide, please. So turning to the specific provision that ends immigration detention in Illinois, as I mentioned, the Illinois Way Forward Act prohibits local government from entering into contracts with ICE for the purposes of federal civil immigration detention. Those jurisdictions that have existing contracts must initiate the process of terminating their contracts by January 1st of 2022. So it's right around the corner. And contract termination provisions really vary by agreement. For the remaining immigration detention facilities in Illinois, and that's McHenry County Jail in Woodstock, Illinois, and the Jerome Combs Detention Center in Kankakee, Illinois, both of their agreements provide that the localities must provide ICE with at least 30 days notice before terminating their contracts. And so we're anticipating that sometime, well, in late January or early February 2022, we could see the shutdown of immigration detention operations in these two facilities. Some of you may have seen that McHenry and Kankakee counties sued Illinois Attorney General in federal court in the Northern District of Illinois, seeking to block implementation specifically of the provision that prohibits local government from entering into detention contracts with ICE. But just this week, that lawsuit was dismissed. And given that there's no injunction in place, we fully anticipate that these detention contracts will be terminated at the beginning of the year. Next slide, please. So again, at the moment, there are just two remaining immigration detention centers in the state of Illinois. That's McHenry County, as I mentioned, Woodstock, Illinois, and the county jail in Kankakee. Through our work at the Detention Project here at NIJC, we've long exposed some of the conditions that our clients face in these facilities. This is supposed to be civil immigration detention, but many of the conditions are punitive in nature, and these are county jails, and in many respects, what our clients face is really indistinguishable from what individuals face who are in criminal custody of these facilities. And so if you want to read a little bit more about the conditions at these facilities, we submitted an amicus brief in this litigation that I just referenced, detailing some of the conditions that we've seen over the years, including delayed access to medical care, inadequate access to outdoor recreation, inadequate food and nutrition. This is work that we've done for many years. Next slide, please. So the Chicago ICE district now is broad, it covers a broad territory. So it covers different states. So the Chicago ICE district office has had immigration detention centers and capacity in Wisconsin, Illinois, Indiana, and Kentucky. As I alluded to earlier, this year, the Pulaski County Jail closed down. That was a decision made by the Pulaski County officials. Kenosha County Detention Center was another facility that recently closed down, and this was right before the pandemic, ostensibly due to concerns regarding the safety of detainees in light of the pandemic. And so with the imminent closure of McHenry County Jail and the Jerome Combs Detention Center, we will see, a substantial reduction in detention capacity in the region, leaving just 3 more detention centers that ICE uses in the region. That's Dodge County Detention Center in the middle of Wisconsin, Clay County Jail in Indiana, and Boone County Jail in Burlington, Kentucky, which is right across the river from Cincinnati. Next slide, please. And I'll turn it over now to my colleague Heidi Altman to talk about some of the just closures advocacy that we did more recently with the closure of the Pulaski County Jail.
Thank you so much, Ruben. Can you hear me okay? Great. Hi, everyone. I'm Heidi Altman. I use she, her pronouns. I'm our policy director. I want to just start by echoing what you've already heard from Ruben, which is just gratitude to all of you who were here today and interested in putting in work to help with, what is an exciting time in the state of Illinois. And so I'm going to talk a little bit about the Pulaski experience, the Pulaski closure experience. But I want to, before we do that, zoom out for a moment to talk about a phrase you'll hear us use, which is the term just closures. So what NIJC and community partners have been engaged in through the closure of Pulaski and are now gearing up for with Kankakee and McHenry is part of a really sustained and exciting national campaign and national effort. NIJC, as many of you know, has called for many years now for a full end or a full phase out to the use of secure detention for immigration in the United States. We base that position on a lot of evidence out there that alternatives to detention, especially when they're community-based and community-supported and follow best practices, are obviously, as far as taxpayers concerned, a lot cheaper, but more importantly, more humane, more just, and that detention is really unnecessary in the immigration space. So what organizations led by national groups like Detention Watch Network and then fueled by community groups and movement building groups, many of whom we're lucky enough to work with here in Chicago and Illinois, and where I am in DC and Virginia and Maryland, are sort of ground up efforts that are calling for the closures of facilities. I want to just state outright that there's been, some of you may have followed in the national press recently, there's been some conversation about sort of what happens when there are local closures, when facilities close and people who are detained there are transferred to other facilities where there may be lesser access to counsel, where it may be harder to be in touch with family members. And just to say that that is part of this. That is obviously something that organizers and advocates are aware of, expect, work to mitigate harm, but that this is part of a larger theory of change toward dramatic reductions and hopefully an eventual dismantling really of the infrastructure that is right now so harmful and used to detain immigrants. A big part of making that harm mitigation real is calling on ICE to acknowledge that when a state like the state of Illinois makes the decision through its democratically elected process that it doesn't want people to be detained there for immigration, the way to be respectful of that state's decision making is to release those individuals who are detained at the time of that shutdown so they can be in community and at home with their loved ones while their cases proceed, rather than transferring them, especially during a pandemic, when we know and we have seen that immigration detention transfers contribute dramatically to the spread of COVID. So that's just a little bit of a sort of context of the just closures work. I'm gonna put in the chat right now that as we are anticipating the Kankakee and McHenry shutdown, we just yesterday delivered a letter to the Department of Homeland Security and Immigration and Customs Enforcement. Some of you may be affiliated with organizations that signed on, calling for ICE and DHS to release those folks who are still now and will be at the time of closure released at Kankakee and McHenry. And that letter really follows the template and some lessons learned from when Pulaski closed down in September. Long and short of it, there were about 50 people detained at Pulaski when the county jail initiated termination of the contract. Many community organizations came together, including NIJC, the Interfaith Community for Detained Immigrants, ICER, the Illinois Coalition for Immigrant and Refugee Rights, many other sort of local groups, and reached out to ICE and said, look, hey, there's this really robust network of legal services and social services at the ready. When people are released, we will support people in their community. That group of community organizations met regularly with ICE throughout the closure and wind down of that facility's contract. There were people from ICE headquarters, as well as sometimes representatives of the ICE field office at that meeting. And our requests resulted in essentially a freeze of transfers that was violated by ICE in a few cases, but largely held. A freeze in transfers during a period of time when the contract was terminating, where individuals, regardless of the status or the procedure of their case, could make a new request to ICE to consider that they be released rather than transferred. In what was sort of a spectacular disappointment, at the end of that period of time with the Pulaski closure, only 3 people were released into the community before the termination of the contract, and everyone else was transferred. Through our ongoing engagements with ICE, the community's disappointment and outrage in that was really heard, and there was actually another round of release reconsiderations after the closure of the facility that resulted in another 12 people being released. So at the end of the day, 15 of those 50 who had been detained were released. We are starting early this time with Kankakee and McHenry and asking that that same mistake not be made and that the release request be meaningfully considered at the outset this time around. NIJC, ICDI, and ICER and other organizations, including OCAD, Organized Communities Against Deportation, are already delivering those asks to ICE in addition to this letter. The last thing I want to note that was really interesting and I think important for those who are going to be taking on release requests for your clients, for those who are detained at McHenry and Kankakee, is that what we saw in the Pulaski closure is that it was very hard to predict which release requests would be successful and which were not. There were people who were released by ICE who were subject to statutory mandatory detention. But who were able to make a claim based on health, mental or physical or otherwise, that their release was nonetheless appropriate. There were people who had final orders of removal who were nonetheless released and allowed to request a stay from their home and in community. So post-order folks, people with mandatory custody, people with what we usually see ICE consider to be fairly serious criminal convictions, who were able to show that they had a robust community of support waiting for them if they were released, who were actually part of those 15 folks who were released through the Pulaski transfer. So I'm gonna stop there and happy to answer questions in chat or at the end about the experience, and I'm sure some of you are on the line who represented folks during that period too, so we can have a discussion there. But for the moment, I'm going to transfer it over to my colleague Dave.
Great, thanks Heidi. So yeah, now let's dive into sort of the an overview of ICE's authority to detain non-citizens and what we can do to advocate for their release. So for those of you who are not immigration lawyers, there is an alphabet soup of government agencies that are involved in immigration enforcement in this country. The 2 main agencies are the Department of Homeland Security, DHS, and the Department of Justice. And then within DHS, there are sub-agencies that it's important to sort of get a sense of what they do and sort of their scope of authority. So the main one that we're going to be talking about today is ICE, Immigration and Customs Enforcement. And then within ICE, there are 2 sub-agencies to think about, Enforcement and Removal Operations, ERO, or the Office of Chief Counsel, OCC. OCC is basically, they're like the prosecutors in immigration court seeking to deport non-citizens, and ERO are the officers who are trying to deport individuals as well. And as we'll talk about in a minute, many individuals actually aren't even subject to immigration court proceedings. And so ERO does a lot of work to deport those individuals. There's also Customs and Border Protection, CBP. They operate on the borders, you know, on the land borders as well as in airports. And then you have U.S. Citizenship and Immigration Services, USCIS. So those are all under the Department of Homeland Security. And then under the DOJ, there's the Executive Office for Immigration Review, EOIR, which is where the immigration court system is housed in the federal government. And so within EOIR, there are the immigration courts, like, for example, the Chicago Immigration Court, and then the appellate body there is called the Board of Immigration Appeals, which the BIA takes the appeals from all of the immigration courts nationwide. So the basic tools of immigration law come mostly from statute and from the regulations. And so the main statutory authority is the Immigration and Nationality Act. The acronym for that is the INA. It's found under Title 8 of the US Code, and sort of like two sort of like broad observations is that there really haven't been major amendments to the INA since 1996. And ICE's detention authority is statutory, so it comes from this act. And then you can find the Code of Federal Regulations, 8 CFR is also really helpful in determining ICE's detention authority and the immigration laws generally. So who are the immigrants who are in ICE detention? It's helpful to think of like a lot of different types of individuals who are going to be in ICE detention. One big group are undocumented individuals. So that means people who have overstayed a visa or who have entered without inspection. And another acronym that you may hear a lot is IWI, individuals who have entered the United States without inspection. So there are workers, family members, there are asylum seekers, and people in ICE detention have either arrived very recently or may have arrived decades ago. So there's a large gamut of individuals there. We'll also see refugees and lawful permanent residents. These people are usually going to be deportable due to a criminal offense because they have a lawful status. They either have refugee status or the lawful permanent residency status, which is the green card. And unfortunately, we'll sometimes see US citizens in ICE detention, which it's illegal for ICE to detain them, but that doesn't stop them. Sometimes we actually do see individuals who are US citizens in ICE custody. So how do these individuals enter the US? And we talk about this because it can actually be important for our release advocacy coming up to understand how they actually entered the US. And so like we spoke about just with the last slide, many people have entered without inspection. So that's like sneaking into the US. Other individuals may have entered on a non-immigrant visa. And an example of that would be like a student visa or like a visitor visa, like a tourist visa. Some individuals may have entered as lawful permanent residents. So when they were admitted to the US, they were admitted as the LPR status. Or other people may be seeking admission at a port of entry. So they arrived at an airport or some other land border and have been seeking to be admitted to the US. And so why are individuals detained? There are many reasons why ICE will choose to detain people, and they can really detain whoever they choose. But these are like some of the classic reasons that we've seen. Just the fact that someone entered without inspection is enough for ICE to detain someone. Same with overstaying a visa. An aggravated felony conviction is also going to land people in ICE detention in most circumstances. we're not going to go into a deep dive into the immigration consequences of criminal convictions, but there are certain immigration offenses that are going to make individuals subject to mandatory ICE detention. And the aggravated felony is actually a term of art in immigration law. And it doesn't actually necessarily mean it has to be sort of an aggravating type of offense, or that it even has to be a felony offense. It's its own definition, which is defined under the INA as many different types of offenses that are going to be considered aggravated felonies. Same with crimes involving moral turpitude. This is also a type of immigration offense that has certain specific immigration consequences. And this one isn't even defined under the INA. It comes from common law, but it's another type of offense that will land non-citizens in immigration custody. Drug-related convictions will also have that consequence. Firearms offenses, crimes involving domestic violence, child abuse, or the violation of an order of protection will also frequently land people into ICE detention. And then really other crimes, like any crime could really have that consequence, including pending charges. We see many individuals in ICE detention who still have pending charges and have no convictions, but that still may land them into ICE custody. So then the next question is, how are individuals detained by ICE? And it's helpful to think about this as being like a few different steps. So the first step would be that the immigrant is apprehended. And this can happen after something as simple as like a traffic stop or a criminal arrest. We do want to note that the Illinois Trust Act, so within Illinois, counties and municipalities cannot hold individuals for ICE. So if there's some sort of arrest and someone's in detention at like a county or a municipality, in Illinois, those government entities cannot call ICE and say, we'll hold this person until you get here. So really in Illinois, ICE is really detaining people at courthouses or at their home or work, and they have to get a little more creative in detaining people. But in other states, that's not the case. In other states, that happens quite regularly, actually, where local municipalities or counties will hold on to people and wait for ICE to come get them. Other times that immigrants are apprehended, it's upon the completion of a criminal sentence or release from a state or federal custody, at immigration interviews. So at USCIS, individuals could be detained at their interview, at a port of entry, again, at the border or at an airport, or of course during ICE enforcement sweeps. So then the next step in this detention process is that the arrest is processed. And that involves the individual being taken to the nearest ICE processing center or detention facility, and that individual is then fingerprinted, interviewed, and then ICE will run a variety of different checks on them. And then after that, one of the following will occur. I spoke about this a little bit earlier, but not all immigrants are entitled to go to see an immigration judge before they're deported. There are actually various different things that can happen that are a much more of a fast track process. And that's what the first 5 of these really are. Reinstatement of removal is when someone has a prior removal order and was removed and then is now back in the US, and ICE, instead of having them go through the immigration court process, they can just reinstate that prior removal order. Execution of a prior removal order is similar, except the idea was the initial prior removal order was never actually executed, and so ICE is then seeking to now execute this removal order. A stipulated order of removal will be someone will just sign papers saying that they don't want to fight their case and they just want to be removed, which actually happens quite frequently for individuals who are in ICE detention and really just want to get out. Then there's something called an administrative order of removal. There are like 2 basic types there. The final administrative removal order, commonly known as FARO, the acronym, that really applies for undocumented individuals who have been convicted of an aggravated felony. they will be subject to this FARO process, again, where ERO, ICE enforcement and removal operations will just issue this FARO, which will mean that they're not entitled to see an immigration judge and go through immigration court proceedings. There's also, under the visa waiver program, individuals can be removed on this more expedited process. They're not entitled to see an immigration judge. There are some exceptions to that, to both of those, but the normal process is this sort of expedited process. And then expedited removal order, that occurs at the border or within 100 miles of the border. CBP, if they encounter an individual there, they can do, again, a faster removal process than by going to an immigration court. And of course, then the last one is removal proceedings would be commenced in immigration court. So just to talk briefly about removal proceedings, these are civil proceedings, they're not criminal. And so the main, a major consequence of that is that there is no right to counsel at government expense. So many individuals, especially those in ICE detention, it's difficult to find counsel. And so many people go forward pro se. The government, of course, is represented, again, by the Office of Chief's Counsel, and their goal is always deportation. They're always seeking to deport people. So it's definitely stacked against individuals, especially those in ICE detention without attorneys. But that being said, some individuals are eligible to seek release from ICE detention and fight their cases and remain in the US. So let's talk about now about DHS's enforcement priorities. There's been a lot of back and forth with this, starting in the Obama administration and then in the Trump administration. But basically, since the beginning of the Biden administration, DHS has issued a series of memoranda outlining ICE's enforcement priorities to come up with sort of like a better system of prioritizing non-citizens for DHS's enforcement. The most recent and updated memo, which is binding now on all of ICE, was issued by DHS Secretary Alejandro Mayorkas on September 30th. So you'll hear individuals call this the September 30th Mayorkas memo. And this is a link to it right here. It's called Guidelines for the Enforcement of Civil Immigration Law. And so let's talk about that just for a minute now. So the guidelines that he set forth is for ICE to execute, to exercise its prosecutorial discretion in seeking to sort of apprehend and deport non-citizens. And the basic idea is that there are approximately 11 million undocumented individuals in the US who are technically subject to being deported or put through removal proceedings, but this memo is really guidance to ICE and DHS generally to say we need to prioritize individuals based on 3 priorities. And these are 2 quotes from the memo, which I think are worthwhile. So in exercising our discretion, we are guided by the fact that the majority of undocumented non-citizens who are subject to removal have been contributing members of our communities for years, and the sole fact that someone is a removable non-citizen should not alone be the basis of an enforcement action against them, which definitely was not the case under the prior administration. Sort of anyone who became in contact with ICE would be sort of prioritized for removal, and so that's not the case now, according to this memo. And the 3 categories that the Mayorkas memo is really talking about here are this threat to national security, threats to border security, and then threats to public safety. So let's talk about each of those in turn. So the threat to national security is somewhat straightforward. It applies to individuals who have engaged in terrorism or espionage or is otherwise a danger to national security. It's different than public safety, which we'll talk about in a minute. The other broad category here, which is an enforcement priority, is individuals who are a threat to border security. And that has a specific definition. So it's individuals who have been apprehended at the border or port of entry while trying to unlawfully enter the US, or individuals who entered the US without inspection after November 1st, 2020. So those are the two main categories. That being said, ICE, the memo is imploring ICE officers to do a case-by-case analysis here if there are mitigating circumstances that really should be considered in whether to go forward with an enforcement action. So really, ICE officers need to look at the totality of the circumstances, even in this threat to border security enforcement priority. And then the last major one is a threat to public safety. And so this is a pretty big one, and we'll talk about this more on the next slide as well. But the broad category is those who pose a current threat to public safety. And this is typically because of serious criminal conduct. There are no bright lines or categories. So there are no like absolute bars saying that certain crimes are going to bar people from or are automatically going to make them a threat to public safety. But instead, this is based on an assessment of the individual and the totality of the circumstances in his or her case. And I just want to outline too that I think it's important to note that this is individuals who pose a current threat to public safety. So, individuals who have convictions or offenses from like many years ago or who have shown significant rehabilitation. I think the arguments we, are making are that they are not like past criminal conduct, does not make them a current threat to public safety, that there are mitigating circumstances that need to be assessed. And these are actually some of the sample factors that are listed in the Mayorkas memo. And this is not, the only factors that are listed, but I think it's helpful in making release requests to actually cite these factors because they're clearly cited in the memo. So there's the aggravating factors, which are, of course, the gravity of the criminal offense, the sentence imposed, the nature and degree of any harm that was caused, the sophistication of the criminal offense, sort of like, was it like pre-planned? Were there a lot of people involved? Things like that. Use or threatened use of a firearm or dangerous weapon, and just, basically the seriousness of a prior criminal record. Those are all going to be aggravating factors. But then, of course, there are many factors that are going to mitigate against sort of this threat to public safety enforcement priority category. And those are, if someone is at an advanced or a tender age, like a young age, if someone has had a lengthy presence in the United States. A big one is if the individual is suffering from a mental condition that may have contributed to that criminal conduct. If the individual has physical or a mental condition requiring care or treatment, the status of that individual as the victim of a crime, or the witness to a crime that is in current legal proceedings, the impact of removal on family members in the United States, such as the loss of a provider or caregiver, the individual's eligibility for humanitarian protection like asylum or other immigration relief, and then military or other public service of the non-citizen or of immediate family members. Okay, so now let's go into ICE release requests specifically and sort of the nuts and bolts of how to draft, submit, and then if needed, escalate those release requests. So just generally speaking, ICE has the authority to release all individuals in its custody, even those subject to mandatory detention under Section 236C of the INA. For those of you who may have done a bond request in immigration court, the threshold question in those types of requests is, does the immigration judge even have jurisdiction over this bond request? Because if someone falls under 236C, they fall under mandatory ICE custody. And what that basically means is the IJ can't engage in a bond hearing for that individual. However, this mandatory custody provision doesn't, it arguably does not apply to ICE. That ICE can release anyone who they have detained. It's, once they detain someone, they can also release them. It really only applies to the immigration judge. And we've seen individuals like Heidi mentioned earlier, we've seen individuals who are technically subject to mandatory custody. They have been released by ICE in the past. And so I think it's helpful to think about of the many types of release requests that you can submit to ICE, it's helpful to think about them in 4 different categories. And we'll talk about each one of these. So there's humanitarian parole. There's a release request that's based on community ties and a lack of danger. There's those that are based on mental or physical health conditions. And then there's another type that's based on prolonged detention for individuals who have a removal order, but are still detained for a long time because ICE hasn't actually effectuated their removal from the US. Let's talk about humanitarian parole first. And this applies to quote unquote arriving aliens, which is a term under immigration law, which means those who are detained at a port of entry, including an airport, by Customs and Border Protection. They are like arriving at the United States at a port of entry. They're eligible for humanitarian parole into the United States under the INA. It's section 212D5. It's important that they have this humanitarian parole relief because they're technically not eligible for an immigration bond from an immigration judge, just based on the specifics of the INA and the way that it's been interpreted by the courts, but they are eligible for parole from ICE. So the requirements here, it's helpful to have a sponsor that has some form of status, like if they have a US citizen or if they're a lawful permanent resident. And basically, this is typically for asylum seekers who have passed something called a credible fear interview, in which they show in an interview in front of DHS that they have a credible fear of returning to their country of origin. Once they've passed that credible fear interview and they can show that they have a place to go and there's like a sponsor, usually those individuals can get released from ICE detention. Okay, now let's talk about general release requests. So for all other detained individuals, ICE is going to consider the following factors. So the first one is, are they a current ICE enforcement priority? And that's what we just talked about a few slides ago, that September 30th Mayorkas memo. And then the other factors are sort of like the general factors that ICE is going to look at for release. And that is whether they're a danger to the community or a flight risk. And of course, these are also included in the Mayorkas memo, but this is just sort of helpful to keep in mind, sort of in our past experience, things that can be difficult to overcome and that you really want to point to mitigating circumstances when you can for these kinds of issues. So alcohol-related offenses, a lot of people with DUIs are detained by ICE because of those DUIs. A lot of people who have violent offenses, or if there's some sort of allegation of gang membership, that's also going to be, potentially difficult to get them out of ICE detention. So you're definitely going to want to point to mitigating circumstances, including like rehabilitation or plans for rehabilitation, if those are issues for your clients. And then flight risk is another big one here. So if there's a history of a failure to appear, like someone did not show up to some criminal court hearing or something like that, that's going to be difficult. Also, people who failed to appear for an immigration hearing will be difficult to get released after that. But also, I mean, if you can point to the fact that someone is eligible for immigration relief, including asylum, like a U visa, or maybe like a family-based petition or cancellation of removal, that's going to be a big factor for flight risk. Because if someone, has like a clear path to some sort of status or immigration relief, that's going to be good for to mitigate any sort of fear that someone's going to abscond. And then again, the strength of family and community ties. So people who have lived in the US for most of their lives or for many, many years, it's also going to be a strong factor against flight risk. And we'll just say be creative with documentation here. I mean, there's no like one thing that you need to submit, and you can have letters of support, you can have letters, you know, from family members, from friends, from employers, churches, things like that. Like all of these things will help when looking at, you know, these kinds of factors for a release request. So let's talk about this third type of release request, which fall under this, that we call them Frayja release requests because they come from an injunction from Faherty v. ICE. And this comes from April 20th of last year. The U.S. District Court for the Central District of California issued this nationwide preliminary injunction in a class action suit mandating that ICE conduct custody redeterminations for medically vulnerable detainees who are at heightened risk of severe illness and death upon contracting COVID-19. So this was at the beginning of the pandemic and was a huge victory to force ICE to do meaningful custody redeterminations for, you know, medically vulnerable people. We just want to note that there's been some more litigation here. There's been some more, there's some updates on this. The Ninth Circuit has actually recently overruled this decision. But for our purposes, for our release efforts for Kankakee and McHenry, the injunction is still actually in effect until at least February 11th, which actually should be 2022, sorry about that, which is the soonest possible date that a mandate could issue from the court, given the timeline for seeking rehearing. So basically this is not over, and really this injunction is still in place until at least February 11th of next year. So we can still submit these Frayja requests and ICE needs to still be following the Frayja guidance. So let's go into a little with some more detail what we're looking at for these Frayja requests. There are these different subclass members that include all individuals detained in ICE custody with one or more of the following risk factors. So the first one is just being over the age of 55 is a risk factor and is a subclass of Frayja. Being pregnant is another one. And then the other big one is having a chronic health condition. And it's defined pretty broadly that there are some that, you know, are definitely, it's obviously chronic health conditions like cardiovascular disease and things like that. But there's some others that you may not like initially think would be a chronic health condition, but really would make someone vulnerable, especially during this COVID-19 pandemic we're in. So some of these are high blood pressure, having a chronic respiratory disease. So that includes asthma and you know, even more serious sort of pulmonary diseases, diabetes, cancer, liver or kidney disease, autoimmune diseases. Another big one is severe psychiatric illness. So mental illness is going to be a subclass for Frayja release requests, a history of transplantation, and someone who has HIV or AIDS. So these are the Frayja subclass members. In doing release requests, if someone falls under one of these categories, you definitely want to identify that and document that with medical records as best you can. And because there's a different process for ICE reviewing these Frayja release requests. So the last category of release requests that we're going to talk about is, again, those who are have a removal order but have been detained by ICE after that removal order for a specific period of time. And so even individuals who are subject to these final orders of removal can still be released from ICE custody. They're not subject to mandatory custody, you know, for the foreseeable future. And that authority comes from INA section 241A3, and they'd be released under something called an order of supervision. And again, this comes about when their detention has become indefinite and their removal is not reasonably foreseeable. So the general requirements for this are that someone has been detained after they've been issued an order of removal for at least 90 days. And then you have to show that their removal is not foreseeable. And so an example of that is the country is not willing to take that person back, or there's some impediment to that country taking that person back. Like for example, like travel bans, based on the pandemic or something like that. And you have to show that that person is not a flight risk or a significant danger to the community. This comes from the Zadvydas case from the Supreme Court, which held that it's unconstitutional to keep people detained post order of removal, in this sort of indefinite detention when really their removal is not reasonably foreseeable. So we just want to know that this is sort of a different type of release request with sort of different requirements. But even if someone doesn't meet every single one of these, it's still important to still try to advocate for their release, because prolonged detention, especially individuals who don't have current proceedings, this is an important way to advocate for their release. Okay, so what can we do here? And really, our goal with this presentation, and in the next few months, is to provide legal support for individuals who are eligible for release from detention at McHenry and Kankakee. And we're doing this by recruiting pro bono attorneys, and then we're going to be leading screening efforts of immigrants who are detained in these facilities in early January to determine eligibility for these kinds of release requests. And if individuals are eligible for release and they don't have access to counsel, we're going to try to connect them with pro bono attorneys to help with these release requests. So just generally speaking, how to contact individuals who are in ICE detention. At McHenry and Kankakee, there are different protocols for scheduling attorney calls. McHenry, there's a phone number that you can call to schedule your confidential attorney call. Kankakee is a little easier. You can email them for call scheduling. And usually you have to schedule calls like a day in advance, but sometimes if there are openings, you can schedule calls on a quicker timeline. Both facilities, thankfully allow documents to be faxed, which this is especially helpful for signatures. If you need signatures from clients, you can get those faxed to you pretty quickly. And we have detailed contact information for both facilities, which we're going to include in materials for those of you who are interested in helping with filing release requests. We're going to send a lot of materials to you, including sample release requests and detailed information on how to contact individuals at these facilities. So then the specifics about submitting release requests. All release requests are submitted by email to ICE. ICE has asked that they're submitted by email. And there's this general email, that's the Chicago outreach email for these release requests. The request must include a signed G28, which is a notice of entry of appearance as an attorney for ICE. It's a 3-page form. It's not that complicated to fill out, but it basically just informs ICE that you are an attorney representing this individual and that ICE can talk to you about this release request, for example. And just want to note that this only applies for release requests with ICE. It's not a formal appearance in front of an immigration court or some other venue. That's actually a different form. For immigration court, it's called the E28. But this does not put anyone on the hook for immigration court proceedings. It's just for advocacy in front of ICE. And so in addition to the G28, of course, release requests should include other supporting documentation, including letters of support, medical records, criminal records as well are really helpful, including police reports, trying to track those down in different states. Different states have sort of different ways of getting those records. A lot of times you can get them online, you can pull them up pretty easily, but sometimes you have to call and do like a quick FOIA request and try to get them within a few days, which is possible. And then how to escalate a release request. I think we're going to bring in Heidi to talk a little bit more about this.
Yes. Hi, Dave. Thanks. I'm here. So we're going to talk about like some more bites at the apple, basically. So Dave has outlined all this great information about how to file a release request. What we have found, well, so I'll start with the ICE case review email, which is on the slide that you're looking at right now. And this is sort of like the first way to formally escalate a release request that has been denied. So you would, you have submitted to the Chicago outreach email that you saw on the last slide and you receive a denial. You can then use this as like an informal administrative appeal email. And this email, ICE case review at icedhs.gov, is staffed by what ICE refers to as an SRO, or a senior reviewing official. We sort of have gleaned that the senior reviewing official is basically a rotating system where field office directors from different field offices across the country rotate in and look at these field reviews. So as you can imagine, that raises some questions about the sort of integrity and independence of the review, and we've had very, very different levels of success with using this. What we wanted to flag here is that in the course of the Kankakee and the McHenry closures, we and our federal policy and advocacy team at NIJC are going to be doing our best to try to keep an eye on sort of the global picture of how the release requests are being adjudicated at ICE. And we'll be here and able to sort of take in and batch together different cases where people have requested release and it has been denied, and there is an argument that that denial was in violation of ICE's prosecutorial discretion policy that you've heard Dave outline over the course of the past few minutes. This is something that we did in varying degrees over the course of the Pulaski closure, and it was quite effective, and essentially was a way to say, look, this case was denied through the Chicago outreach email, it was denied through the ICE case review email. We think, given the closure of this facility and sort of the importance of this moment with the end of detention in Illinois, someone more senior, either at ICE or even in some cases at DHS headquarters, needs to come in and take a look. And what we saw during the Pulaski closure is that there was actually sustained engagement from the leadership level that resulted in some people who had been denied through these first two steps then being granted release. I'll also note that there have been some other closures nationally, including the closure of the Hudson County Jail in New Jersey, where another national organization, the National Immigration Project of the National Lawyers Guild, played this role of sort of collecting and batching together cases that needed to be further escalated, and also had some success in getting some folks released that way. So over the course of this process, we just want you to know that we are here. All you need to do is email me, and my email address is on this slide. It's haltman@heartlandalliance.org. Attach the PDF of the release request that you sent, either to the Chicago outreach email or to the ICE case review email, and a copy of the denial that you received. And we will then get back in touch with you and explain our thoughts on how we might batch it together with others or send it along individually, and can also sort of serve as a liaison if then ICE or DHS leadership comes back and says that they have specific questions about the case or might need additional pieces of evidence. So I think with that, I will toss back to you, Dave. Thanks.
Great, thanks, Heidi. So then also just want to briefly flag that some individuals may actually be eligible to seek bond from an immigration court in addition to these release requests. I talked about this a little bit earlier, but there are specific statutory requirements for immigration bonds. And so those who are eligible, though, they have to demonstrate kind of a similar type of factors for release requests, namely that they're not a flight risk and they're not a danger to the community. If you are interested, in addition to filing release requests for individuals, if you're interested in filing a bond motion for someone in immigration court, you can also let us know. Sort of like different procedures for that, but there's a great training on this that was just done for CVLS, and so there's a link to that here. So if you're interested in that, definitely let us know, and that'll be really helpful as well. So here are the next steps and how to sign up. So if you're interested, and we hope you all are, in registering to help take on a client to do an ICE release request, you can go to this website where you can use this QR code in the top right hand part of the screen here to sign up. And there you'll indicate whether you just want to do an ICE release request or whether you'd also be interested in doing a bond motion in immigration court. Just want to flag a few things that this is a completely virtual process. So, people can do this from wherever they are. Physical visits to the facilities are not expected at all. And really, in most cases here, they're not allowed by the jails. And attorneys do not have to be admitted in Illinois to submit these release requests. So once you sign up, we will send you, a lot more information, including background and case materials with instructions on how to submit these release requests and a lot of samples so that you can build upon those for your individual clients. And then we'll also assign you a client to do a release request for. I also just want to note that for immigration attorneys who are here, if you already have clients who are detained at McHenry or Kankakee, please email me. My email is here, just so that we know that your client doesn't need an attorney. Basically, over the next few weeks, we are doing this huge effort to try to identify everyone who is detained at McHenry and Kankakee. And of course, we want to prioritize those who do not have counsel. And so if you have clients who are already there and you're already planning on doing these release requests, which we highly encourage you to do, we just want to make sure that we're not, or that we're focusing on individuals who really do need an attorney assigned to them. So you can just let me know that you have people detained there. That would be great, just for our own record keeping. So let's open this up to questions. Any questions at this time? Feel free to put those in the chat. Okay, I think I just opened up the right thing now. Okay, first question is, to which facilities have detainees been transferred out of Illinois to date? It's a great question. With the Pulaski shutdown, we got a little bit of a taste of this. Many people from Pulaski were transferred to either Kankakee or McHenry. I think most of them were actually transferred to Kankakee, of the ones who stayed in Illinois, but some have been were actually also transferred to a facility in Kansas. So I think based on just the location of Pulaski being like extremely far in the south of Illinois, and just based on bed space at the time, it seems like it was one of those two facilities, either Kankakee or this facility in Kansas. So we're not sure what the next steps will be, for individuals who are not released from McHenry and Kankakee, but we're hoping to have, again, like this robust release request effort so that we can try to get as many people as possible released instead of just transfer someplace else. For those of us who are not attorneys, how can we help? It's another great question. So to file release requests and have that G28 on file, you have to either be an attorney or a BIA accredited representative. So if you're not either of those, you could still help us by doing intake calls with individuals. We're, again, like I said, we're in the process of trying to identify everyone in these detention facilities who do not have attorneys, who need help with these release requests. So I would still go to that website and just try to indicate there that even though you're not an attorney, you want to help by doing intake calls, especially if you can speak Spanish or like another language. That would be really useful. And you can definitely help us with that process to try to identify those individuals. So another question here, if we're interested in volunteering, is there an attorney that can supervise and we can ask questions to? Yes, so if you're interested in doing this, we're hoping to provide many background materials that will help individuals so that it should be pretty intuitive of like what they need to be doing in their cases. But that being said, like we are available to help with questions. We're not going to sort of like, we're not going to like sort of run this process for you. We want you to sort of like take this and kind of run with it. But definitely if questions arise, like we are available to answer them and to, help strategize different situations. So yes, like we will definitely be there to help. We really think, this is going to require maybe like 6 to 10 hours of work because it's really just, gathering, documents and speaking with the clients and then, writing up these release requests, which are, this isn't like a long like legal brief or anything like that. It's really kind of a straightforward release request for these individuals. Have you filed habeas petitions to stop transfers? Any orders issued to stop the transfers? No, we haven't done like a class action sort of habeas petition or like something to try to stop transfers. But yeah, we've definitely, with our own clients, when we've done release requests or bond hearings and haven't been successful, we've absolutely done habeas petitions and have been successful with the ones who we've been filing for, in many cases. But to my knowledge, we haven't done sort of like a broader effort to stop those for like everyone detained at those facilities. Okay, here's another question. For those transferred, which circuit case law has been used in their individual hearings? 7th Circuit has better case law than the 8th and 5th Circuits. Yeah, definitely. And this is another great question. So for individuals who are, in immigration proceedings at the Chicago Immigration Court, we have the benefit of being, under the precedent of the 7th Circuit, because that's where the Chicago Immigration Court is located. I think those, and this actually happened with the Kenosha shutdown, which was at the beginning of the pandemic. Many of anecdotally, like many of my clients were transferred to detention centers out of the Midwest, but their cases were still in the Chicago Immigration Court, and so they still benefited from that, like having the 7th Circuit precedent. We think the same is going to happen here for individuals, even if they don't get released and they get transferred to other facilities outside of the geographic area of the 7th Circuit. We think that, if they still have immigration cases proceeding in the Chicago court, that they should go, they should continue with that Chicago Immigration Court proceeding. We'll have to see what happens, but that's our understanding. Like another example of that is, Boone County Jail is technically in Kentucky, but because it's under the administrative control of the Chicago Immigration Court, it's the 7th Circuit that applies there. So we think that may be the case for individuals who are transferred, but we'll definitely have to see whether, like, for instance, like if OCC tries to do a motion to change venue or something like that, then that would obviously complicate that.
Thanks, Dave. On that last question, I'll just add that recently we have come across Illinois residents, for example, who have been venued in the Kansas City court, which obviously falls under the 8th Circuit, as Maria was noting. And in some of those cases, we've actually been successful in getting the court in Kansas City to transfer venue to the Chicago court. So we'll definitely want to keep an eye out to see if folks, particularly Illinois residents, are transferred out of state, and would be interested in hearing about any efforts to try to get venue changed to Chicago.
Yeah, even at Pulaski, even when Pulaski was still open, it would be Illinois residents would somehow, they'd be venued in Kansas City, which, didn't really seem to make sense to us. But yeah, we were successful in doing venue changes back to Chicago. Yeah, and one of the questions came in is like a sample motion to change venue would be helpful. And yeah, we can absolutely provide that in the materials as well. Yeah, I think typically for these motions to change venue, it was like, it's like the council is located in Chicago. It's like easier to come here, but now everything is virtual, even in immigration court. So it may be a little more complicated, but that hasn't been a problem in our experience so far with the Kansas City court. Yeah, so another question is just the recent experience for, what has the recent experience been for the Chicago ICE outreach to make a decision on release requests? I think like this is what Heidi was talking about. Like our most recent experience was with the Pulaski shutdown, and it was, at first it was very difficult. The Chicago local office, of the 50 so people who were detained at Pulaski, only 3 ended up being released in the initial outreach. And that's why, the escalation in that experience was so important, that we really needed to take this up the chain as much as we could. I think it's sort of an open question now, like after that experience, what it's going to be like for the next 2 detention centers. Hopefully, it won't be as difficult in the first round, but I guess we're just going to have to wait and see. But we hope. I mean, the best thing we can do is just to have really solid release requests, from everyone, for everyone who's interested in doing this, so that we can really bolster, these requests and make it, much more likely, even if the Chicago local office initially denies the request, that maybe someone down, someone further up the chain will look at it and make a different decision. Another question is, what's the turnaround time for decisions to be made? Another great question. The local ICE office, it sort of depends. I mean, unfortunately, sometimes it's a very quick turnaround within like a few days, and other times it's taken longer. What we found with the Pulaski shutdown, it seemed like they were devoting a lot of resources to adjudicating these requests. So we got them pretty quickly. I mean, there were some differences. I mean, some people didn't hear back for some time. So we don't know for sure, but we think like it might, they might turn these requests around maybe within like a week or like a few days. The ICE case review is usually pretty quick, just anecdotally in my own experience of those that I've done. It could be like 2 days, 3 days. We could get a decision on that. So we'll have to see, how long this takes, but it usually takes about a week. I don't think it takes like multiple weeks usually for these release requests, but it depends. Some of them have been longer. Some of them it does take longer to do those decisions.
Yeah, thanks, Dave. And where we have seen a delay at the local level, sometimes just escalating it even in the absence of an answer from the local folks, so triggers a prompter response, somehow forces the local folks to issue a decision quicker. So that may be a recourse, not also in the case of a denial, but also where we're waiting too long for a response from local deportation officers.
Yeah, and Dave and Ruben, this is Heidi. I realized that I forgot to mention when I was speaking earlier that we're also going to be bringing staff members for members of the congressional delegation for Illinois, so Senators Durbin and Duckworth and the full House of Representatives delegation, sort of bringing them up to speed, keeping them up to date on what happens with the Kankakee and McHenry closures, and several of them were particularly active during the Pulaski closure. So the reason why I mention that is because they will be briefed, and if there are cases where we feel like there's a delay in adjudication, or where support from a member of Congress who represents either the person or one of their loved ones may be helpful, we're also here and happy to assist with reaching out for that intervention as well.
Great. Great. Okay. Well, if there are no more questions, we can end there. We can end a little early. If you have other questions, please feel free to reach out to us. You could reach out to me directly at my email a few slides ago. Happy to help with this. But yeah, we really hope this was helpful to everyone. And we would really love to have as many of you can volunteer as possible. We're going to need as much help as we can get to really help as many people as we can get released instead of transferred when these closures happen early next year. So thank you. There is here's our contact information too. You can contact us there. And there's also, here's a QR code as well for an evaluation. You can fill out an evaluation for this presentation. Let us know how we did. Any ideas on how we could have made this better would be much appreciated. So thank you very much. And we hope to hear from you all soon.